Hello and welcome to 60 Seconds with Sergio. I am your host, Sergio Cabanas, attorney at law here in Florida. Thank you for joining us today. Today's question is, Sergio, it appears that my spouse and I are heading towards a divorce. My spouse is insisting on a mediation to try to settle all of the issues, but we have so many disagreements that I believe that a mediation would be a waste of time. Can I be forced to attend a mediation? So the best way of answering this question is by first reviewing what is a mediation. Basically, a mediation is where all the parties get together to meet with an independent third person known as a mediator. He or she will discuss ways in which your case will be settled out of court. The main objective, of course, is to settle this case without any further litigation. So now that we know what a mediation is, let's take a look at the circumstances for this request for a mediation. If a request for mediation is from your spouse or their attorney if they have one, and you believe it would be a waste of time, you're not obligated to attend any mediation whatsoever, especially if there's no divorce action actually filed in the court system. However, if there is a divorce case, mediations are often ordered by the judge because it's shown to be an effective way of settling the cases without the judge and the parties being subjected to a trial. If a judge issues an order that requires the parties to attend a mediation, you should and must cooperate and attend the mediation, even if you don't feel like it's going to settle the case. Once you appear in mediation, you always have the option of ending it as soon as it's reasonably possible. And at a minimum, you'll be able to show the judge that you complied with the court order of attending the mediation. I suggest, however, that you view the mediation in a positive light as much as possible because it could actually help you settle your case once and for all, even if you think it's possible that it won't settle. As an attorney, I've gone to many mediations where I thought there's no way a case would settle, and I've been pleasantly surprised. If a mediation has helped settle many other cases, it may help settle yours, even if you think it's virtually impossible. If a settlement is possible, it would help you avoid the ongoing expense of litigation and avoid the risk and uncertainty of having a judge decide your case, instead of empowering you to make a decision on the outcome of your case. Also, it would help you avoid a lot of future stress by simply closing this chapter in your life so you can focus on more important things. Also, keep in mind that even if you don't fully settle your case, there are other possible results in a mediation. For example, it may be possible to reach a partial settlement that settles at least some of the issues in your case, and it helps avoid the needless, unnecessary litigation on these settled issues and open the door to a full settlement on the unresolved issues later, or at least a trial on just those limited facts that have not yet been settled. Even in the worst case scenario, where settlement is not possible and it's not reached in your case, mediation is still an effective tool for both parties to understand each other's position, and you get insight into their litigation strategy, which may help settle the case later, or it may help you or your attorney better prepare for trial. So you can see mediation has many other purposes other than trying to reach a full agreement, even though that's the ultimate objective. The bottom line is that you have very little to lose and a lot to gain by attending a mediation, even if you believe it may not work and even if you're not obligated to do so. I hope this short video provided you some guidance on how to handle a request for mediation. Thank you again for joining me today, and as always, stay informed so you could stay strong.